Case 1, Megan Hargan. On July 14, 2017, Megan Hargan grabbed a loaded gun and ended the lives of her 63-year-old mother and her 24-year-old sister. The same home where her mother had accommodated her. The same home where her younger sister still had dreams ahead of her. After the killing, she rearranged the crime scene before leaving through the front door. Megan Hargan was 34 years old when she carried out this crime inside her mother's upscale home in McLean, Virginia. Her mother was Pamela Hargan, a senior defense contractor executive, and her younger sister was Helen Hargan, a recent university graduate just weeks away from starting an independent life. What makes this case so striking is that the scene was deliberately staged to frame one victim for killing the other, a detail that took forensic investigators years to fully unravel. But what could drive a daughter and a sister to cross that irreversible line? Let's jump into the details of this case. Every family has a version of itself that exists only behind closed doors. There are conversations that never leave the kitchen. There are resentments maintained over years with the kind of discipline that looks, from the outside, like peace. When Fairfax County investigators arrived at a McLean, Virginia home on July 14, 2017, the exterior of the house offered nothing alarming. The neighborhood was quiet. The street was lined with well-maintained properties. Nothing had been broken. That stillness, it turned out, was part of the problem. Pamela Hargan was 63 years old and a senior executive at Lockheed Martin, a major defense contracting firm. She had two daughters, Megan, then 34, and Helen, 24. The family home was valued at over $1.3 million. Pamela had paid for it with decades of professional discipline. In the period leading up to July 2017, she was directing financial resources toward Helen, her younger daughter, who had recently graduated from Southern Methodist University and was preparing to purchase her first home. Helen had a plan. She had a future. She had a boyfriend named Carlos Gutierrez who was attentive and devoted to her. Megan Hargan was also attempting to move forward. Her husband was serving in the military. She had been living in Pamela's home with her young daughter. She had identified a property in West Virginia she wanted to buy. The closing required a large sum of money. On July 13, 2017, she initiated a wire transfer of more than $400,000 from Pamela's Capital One account to a real estate title company. The bank's fraud detection systems flagged the transaction. A representative called Pamela to verify it. Pamela had not authorized the transfer. She froze her accounts immediately and was, by all accounts, deeply shaken. The accounts were not to be touched, she said. What breaks inside a person when they realize the exposure is complete? When the cover story has already unraveled, and there is no obvious path back to plausible innocence. Prosecutors argued that these questions shaped what happened the following morning. On July 14th, Megan attempted the wire transfer again, this time using her mother's phone to answer a call from the bank. By then, the situation in that house had already changed in ways that could not be undone. Helen Hargan was on the phone with Carlos Gutierrez around 11:30 that morning. She told him that Megan had confessed to harming their mother. Helen sounded frightened. She asked him to act calm. Her texts then became irregular. Then they stopped entirely. Carlos called 911. Officers arrived to find a carefully arranged scene. Pamela's body in the first-floor mudroom, face down, covered with a blanket and a dog bed. Helen's body upstairs in the bathroom. A single fatal gunshot wound to the top of her head. A .22 caliber rifle, registered to Megan's husband, had been placed between Helen's legs with the barrel pointing upward. The staging was intended to suggest that Helen had taken her own life after harming their mother. The staging was thorough. It was also imperfect. Both victims' cell phones had been wiped clean, no fingerprints, despite both having been recently handled. Gunshot residue was present on Megan's hands. Forensic examination of the rifle grip recovered DNA that did not belong to Helen. It belonged to Megan. The wound trajectory on Helen was inconsistent with the position and angle of the rifle. A firearm expert testified at trial that the suicide scenario the scene was designed to represent was not physically possible without assistance from a third party. When Megan left the home around 1:30 in the afternoon, she told investigators later that her mother and sister had been arguing. She said she had walked away from a family dispute. She maintained this position for more than a year. She was arrested in November 2018. The first trial in 2022 produced a conviction on 2 counts of first-degree murder and accompanying firearms charges. A life sentence was recommended. Before it could stand, however, a juror was found to have conducted an unauthorized home experiment with a rifle, testing the defense's theory about the plausibility of Helen's wound as self-inflicted. That juror had shared the results with other members of the panel, in direct violation of court instructions. The conviction was vacated and a retrial ordered. The second trial concluded in September 2023. Deliberations lasted fewer than 2 days. The defense argued again that Helen had killed Pamela in a dispute over her boyfriend before turning the gun on herself. Forensic testimony again dismantled this. The DNA on the rifle grip, the gunshot residue on Megan's hands, the wiped phones, the wound trajectory, the $400,000 wire transfer attempted the morning of the killings. On January 26, 2024, Megan Hargan was sentenced to 2 consecutive life terms in prison plus 6 years for the firearms charges. She was approximately 41 years old at the time of sentencing. Virginia had abolished the death penalty in 2021, removing that possibility from the sentencing calculus. The consecutive life terms, however, meant that the combined weight of what happened in that McLean home on a July morning was now distributed across her entire remaining life. Helen Hargan was 24. She had been frightened in the last minutes of her life and had tried to get help. She had been weeks from independence, from her own home, from the next chapter of a life that was still forming. Carlos Gutierrez carried the recording of that final phone call as evidence into 2 separate trials. He had answered his phone on an ordinary Saturday morning. What he heard on the other end was something no ordinary morning is supposed to contain. Pamela Hargan had shared her home and her finances with her daughter during a difficult period. Whether the distribution of her resources between the 2 sisters was as imbalanced as Megan believed is something that cannot be adjudicated now. What 2 separate juries adjudicated in nearly identical verdicts was what Megan chose to do about it. That verdict has now been confirmed twice, through 2 separate proceedings, by 2 separate groups of 12 people who reviewed the same evidence and arrived at the same conclusion. The staging failed because forensic science is more patient than panic. The DNA on the rifle grip waited. The wound trajectory waited. The gunshot residue on Megan's hands waited. Every element placed to tell one story ended up telling another. Case 2. Veronica Youngblood. On the night of August 5, 2018, a mother gave her 2 young daughters what appeared to be a bedtime treat, then retrieved a handgun and ended the lives of both children in their beds while they slept. There are cases where the motive is complicated. There are cases where investigators spend months assembling a picture of why someone did what they did. And then there are cases where the person responsible explains it themselves, clearly, directly, in their own words. And the explanation is somehow harder to hear than silence would have been. Veronica Youngblood's case belongs to the second category. She told police what she had done and why. She told her ex-husband. She told anyone who would listen. What she said, stripped of any surrounding context, was that she had targeted her daughters to cause maximum pain to their father. Veronica Youngblood was approximately 32 years old when she carried out the attack in McLean, Virginia. Her victims were her own daughters, Sharon Castro, 15 years old, and Brooklyn Youngblood, just 5. What shook the courtroom was not only the act itself, but an audio recording played at trial. A 15-year-old on the phone with emergency services, describing what had just been done to her. Youngblood's defense argued that severe mental trauma had impaired her judgment. The jury did not agree. What could have pushed Veronica Youngblood to direct her anger at two children who had nothing to do with her grievances? Let's break down exactly what happened. Veronica Youngblood and Ron Youngblood had a history that most people would describe as complicated even before the events of August 5, 2018. They had met through sex work, married in 2009, and had a daughter together named Brooklyn in 2012. Sharon Castro, 15 at the time of the crime, was Veronica's daughter from a previous relationship whom Ron had helped raise. The marriage deteriorated through years of instability and mutual accusation. By 2018, a custody battle over Brooklyn was actively ongoing. Ron had plans to relocate with Brooklyn to Missouri that very weekend. Veronica was opposed and had made her opposition known. On July 27, 2018, 9 days before the murders, Veronica purchased a 9mm handgun. There was nothing spontaneous about what followed. She later confirmed to investigators that she had planned both the killings and her own death. The plan included sedating the girls before carrying it out. She bought the gun. She obtained melatonin-laced gummy bears. She waited. On the evening of August 5th, she gave both girls the gummy bears, presented as a treat to help them sleep. Sharon was 15 years old. Brooklyn was 5. The medication took effect. Both girls were sedated in their beds in the family's McLean, Virginia apartment. What came next was not impulsive. Every element of that night, the 9-day lead time, the purchased weapon, the deliberate sedation, placed it firmly outside the category of a momentary breakdown. Veronica entered Sharon's room first and shot her. Sharon was struck in the back and the chest. Despite her injuries, she regained enough consciousness to call 911. The recording captured Sharon identifying herself as having been shot. She said she did not want to die. While Sharon was still on the line with the emergency dispatcher, Veronica moved to Brooklyn's room. The 5-year-old had been sedated in her bed. A single shot to the head ended her life immediately. Veronica then left the apartment. She did not call for help. She did not remain at the scene. She contacted Ron Youngblood by phone. She told him what she had done. She said she hated him. Loudoun County deputies later found the handgun on Ron's porch. Sharon succumbed to her injuries. Both girls are gone. Veronica was arrested shortly after and confessed. She told investigators she had intended to take her own life as well, but had not followed through. At trial, the defense raised a mental health argument. Veronica had documented trauma, a childhood in Argentina marked by poverty, physical and sexual abuse, and a turn to sex work as a teenager to support herself and her older daughter. Experts testified to complex PTSD and dependent personality disorder. The defense argued that these conditions impaired her capacity to appreciate the wrongfulness of her actions. The jury rejected the argument. The evidence of premeditation was too structured and too deliberate. A 9-day window between gun purchase and killings. A plan involving sedation. A deliberate sequence of events. These were not the hallmarks of a person unable to form intent. The trial drew significant attention for several reasons. Sharon's 911 call was played in open court. The audio, in which a 15-year-old described being shot and expressed a desire to live, created an audible disruption in the courtroom. Veronica herself had outbursts during proceedings. During sentencing deliberations, she reportedly screamed at prosecutors, demanding to know why they had left her alone with the children, before being removed from the courtroom. The sentiment in that outburst, redirecting responsibility toward others, had been a thread throughout the proceedings. The jury recommended 78 years, 36 years per murder count and 3 years per firearms charge. The court imposed the recommendation. Virginia had abolished the death penalty in 2021, removing capital punishment as an option regardless of the facts. Ron Youngblood offered a victim impact statement expressing both grief and his position that continued imprisonment was sufficient. He said he had never believed she would harm the children despite knowing the depth of her animosity. Veronica Youngblood was serving her sentence in the Virginia prison system. Post-conviction, defense indicated plans to appeal. The grounds were not specified in widely available reporting, and the appeal status as of this writing remained unresolved in publicly accessible sources. Sharon Castro called 911 from a bed where she had been shot while sedated. She identified herself and stated clearly what had happened to her. She was 15 years old and had already survived considerably more than most teenagers ever face. She spent the last minutes of her life trying to get help for herself and possibly for a 5-year-old sister who could not ask for help herself. What was taken from them deserves to be said plainly, without euphemism. 2 children lost their lives not to circumstance or illness or accident, but to a deliberate sequence of decisions made by the person who was supposed to protect them. Case 3. Piper and Roundtree. On the early morning of October 30th, 2004, Piper and Roundtree, a lawyer from Texas, wore a blonde wig and got on a plane using another person's identity, drove to a quiet neighborhood in Virginia, waited in a driveway for a man to come outside, and shot him twice before leaving for Texas before sunrise. What transforms a person trained in the law, someone who built a career arguing for justice, into someone willing to take it entirely into their own hands? There is no easy answer to this question, but the details of this case will make you think hard about what happens when grief turns into obsession. Piper and Roundtree was 44 years old at the time of the crime. The man she shot dead was Fred Jablin, 52, a well-regarded communication professor at the University of Richmond who was raising 3 children on his own in Henrico County, Virginia. The disguise Piper used, her sister's identity, a purchased wig, a flight booked under a different name, suggested months of deliberate planning, not a moment of impulse. But what really drove Piper Roundtree to plan and execute this with such precision? Let's uncover the details behind this case. Most people, when they encounter a problem they cannot solve through ordinary means, spend their energy looking for a different approach. They negotiate. They withdraw. They accept outcomes they did not choose and reconfigure their lives around them. What makes Piper and Roundtree's case distinctive is not the depth of her grievance. What makes it distinctive is the architecture of the solution she constructed. A wig, a borrowed identity, a gun range visit, a purchased airline ticket under her sister's name, a pre-dawn drive to a home she once shared with the man she intended to kill. Most people, handed the same grievances, never arrive at any of that. Piper Roundtree was born in 1960 and trained as an attorney. She met Fred Jablin when she was a student in one of his communication classes at the University of Texas. They married in 1983. Fred encouraged her law school ambitions. They had 3 children, Jocelyn, Paxton, and Callan. In 1994, the family relocated to Virginia when Fred accepted a position at the University of Richmond, where he became a respected professor of communication. Piper struggled with the move. She was far from her family in Texas, especially her sister Tina, and the distance weighed on her. She was treated for depression. She accumulated significant credit card debt. Allegations of an affair emerged during the marriage's unraveling. Fred filed for divorce. The custody proceedings were contested and ultimately resolved in 2002 in Fred's favor. He received full custody of the children and the house. Piper was ordered to pay child support and granted visitation. She moved back to Houston, near her sister Tina, and attempted to rebuild. The rebuilding did not go smoothly. She fell behind on child support obligations, nearly $10,000, owed by late 2004. She attempted bankruptcy twice. The children remained in Virginia with Fred, who was providing a stable home while advancing his academic career. Prosecutors later argued that the accumulation of these losses had calcified into a plan. The custody ruling, the financial obligations, the geographic distance from her children, the perception, however accurate or distorted, that Fred had taken something from her that could not be returned. What emerged from that accumulation was not a petition for modified custody or a bankruptcy proceeding. It was a shopping trip for a blonde wig. It was a visit to a Houston gun range using her sister's identification. It was a flight from Houston to Virginia booked under Tina Rountree's name. On October 28, 2004, Piper flew from Houston to Virginia in disguise, carrying a .38 caliber revolver she had checked onto the Southwest Airlines flight. She checked into a hotel near Richmond on the nights of the 28th and 29th. On the morning of October 30th, a Saturday, Halloween weekend, she drove to the Henrico County home where Fred lived with their 3 children. Fred Jablin, 52 years old, woke early, made coffee, and stepped outside in his bathrobe to retrieve the morning newspaper. It was around sunrise. Piper was waiting near his vehicle in the driveway. She ambushed him, firing twice, once in the arm and once in the back. He collapsed near his SUV. A neighbor walking dogs heard the shots and called police. Due to early morning darkness and the position of the body, it took approximately an hour to locate Fred. He was pronounced dead at the scene. The children were asleep upstairs. Piper drove to the airport and flew back to Texas via connection. Cell phone records placed her device in the Richmond area during the relevant time window, before tracking northeast. Evidence from the investigation was expansive. Records from the gun range, receipts for the wig and related items, flight documentation under Tina's name, cell tower data, and ballistic analysis linking the recovered rounds to the purchased weapon. Tina Rountree was later found to have assisted in disposing of evidence, the wig among other items, and pleaded guilty to a misdemeanor charge, receiving 9 months of community service. Piper's trial in February 2005 lasted less than 2 weeks. The jury deliberated for under an hour. Defense counsel argued that Tina, who had shared access to similar items and had her own complicated relationship with Fred, was the actual perpetrator. Piper testified, but came across to observers as evasive and cold. The forensic trail was too complete. She was convicted of first-degree murder and use of a firearm on the counts charged and sentenced on May 6, 2005, to life in prison plus 3 years. Post-conviction, Piper maintained her innocence and raised allegations that grew progressively broader. Corrupt investigators, conspiracy, police misconduct, and implications aimed at Fred's brother Michael, who had assumed custody of the children after the murder. None of these allegations resulted in any change to her conviction. Virginia courts upheld the verdict through multiple appeals. Parole eligibility began around 2020, when she reached approximately 60 years of age. Each bid has been denied. She remains incarcerated. Fred Jablin was a professor who had rebuilt his life with care after a difficult divorce. He was raising 3 children on his own, maintaining a professional career, and providing the kind of stability that post-divorce parenting at its most demanding requires. He stepped outside on a Saturday morning, expecting a newspaper. The person waiting beside his car was someone who had once shared that house and had decided, with great deliberation and over a period of days, that he should not leave it alive. His brother Michael, who took in the children, expressed relief when the verdict was confirmed. The children grew up without their father and eventually without their mother in any meaningful parental capacity. That is the total accounting of what the .38 caliber revolver in a Henrico County driveway cost. Case 4. Teresa Wilson Lewis. In the early hours of October 31, 2002, Teresa Wilson Lewis connived with 2 men to have her husband and his son killed. On the day of crime, the 2 armed men entered through an unlocked back door of a trailer home and opened fire on the sleeping pair, while Teresa Wilson Lewis waited in the kitchen, fully aware of what was happening just rooms away. Some cases arrive in the public record with a clear center of gravity. The evidence points in one direction. The confession confirms it. The motive is documented. And yet something about the outcome continues to generate argument for years afterward, not because people disagree about what happened, but because they disagree about what it means. Teresa Wilson Lewis was 33 years old when the crime was carried out in rural Pittsylvania County, Virginia. The victims of this heartbreaking story were her own husband, Julian Lewis, who was 51 at the time, and his son Charles, known as CJ, who was 25 at the time and also a U.S. Army reservist. What makes this case particularly controversial is that the two men who physically carried out the act received life sentences, while Teresa, who never fired a single shot, was sentenced to death and executed on September 23, 2010, making her the first woman executed in Virginia since 1912. This case raises questions about justice, culpability, and the sentencing disparity, which have never fully been resolved and continue to generate debate more than a decade after her execution. What really drove Teresa Lewis to arrange the taking of two lives for financial gain? Let's get into the full story. Teresa Wilson was born on April 26, 1969, in Danville, Virginia. She grew up in poverty. Both of her parents worked in a textile mill. She dropped out of school at 16, married young, had a daughter named Christy Lynn Bean, and divorced. The years that followed were marked by instability, alcohol, prescription painkillers, low-wage employment, and a life that did not accumulate the way lives are supposed to. Psychological assessments, conducted years later, would identify borderline intellectual functioning, an IQ assessed at approximately 70 to 72, along with dependent personality disorder. In the spring of 2000, she met widower Julian Lewis at the Dan River Textile Mill, where both worked. They moved in together quickly and married. Julian had children from a previous marriage. In August 2002, Julian's son Charles, known as CJ, a United States Army reservist preparing for potential deployment to Iraq, took out a $250,000 life insurance policy naming Julian as primary beneficiary and Teresa as secondary. That policy and the financial situation surrounding it became the documented motive for what followed. By the fall of 2002, Teresa had formed relationships with two younger men she encountered at a Walmart, 21-year-old Matthew Schallenberger and 19-year-old Rodney Fuller. Prosecutors presented her as the instigator, the person who identified the financial opportunity, proposed a plan, provided funding for weapons, and organized the execution. She gave the two men $1,200 to purchase shotguns and ammunition. A first attempt to ambush Julian on a road failed. On the night of October 30th, 2002, Teresa left the back door of the family trailer unlocked and waited in the kitchen while Schallenberger and Fuller entered during the early morning hours. Julian Lewis, 51, was shot multiple times in his bedroom while he slept. CJ Lewis, 25, was shot multiple times in his own room. When CJ was found still breathing, Fuller returned to finish what had been started. After the shootings, Teresa approached her dying husband. She removed cash from his wallet and divided it with the men. She waited approximately 45 minutes before calling emergency services, reporting an unknown home invasion. Deputies arrived while Julian was still clinging to life. He reportedly told them his wife knew who had done this to him. Teresa was caught attempting to withdraw $50,000 from Julian's account using a forged check shortly after the murders. Under questioning, she confessed fully. She pleaded guilty on advice of counsel in June 2003, anticipating that cooperation would result in leniency. The judge, who described her as the head of this serpent, sentenced her to death. Schallenberger and Fuller, who had physically committed the acts, received life sentences. That disparity became the engine of a sustained advocacy campaign that lasted 7 years. Supporters argued that Teresa's intellectual limitations made her susceptible to influence rather than capable of masterminding a conspiracy. John Grisham was among those who publicly opposed her execution. An affidavit from Schallenberger, who had an assessed IQ of 113, suggested Teresa had been eager to please and was not particularly perceptive. Post-conviction evaluations pegged her IQ at 70, the threshold for intellectual disability protection under Atkins versus Virginia. Virginia courts ruled she did not meet the legal standard for that protection. Appeals were denied at every level. Governor Bob McDonnell denied clemency twice. The United States Supreme Court declined to issue a stay, with Justices Ginsburg and Sotomayor dissenting. International attention included commentary from Amnesty International. Iran's government made public statements invoking the case in discussions of American justice. On September 23, 2010, Teresa Lewis was taken from death row at the Fluvanna Correctional Center, where she had been described as a cooperative and spiritually engaged prisoner, to Greensville Correctional Center. Her last meal was fried chicken, sweet peas, Dr. Pepper, and pie. She expressed apology to stepdaughter Kathy, one of Julian's children from his prior marriage. At 9:13 in the evening, Teresa Wilson Lewis was executed by lethal injection on September 23, 2010, at Greensville Correctional Center in Virginia. She was the first woman executed in Virginia since 1912. She was the first woman in the United States executed by lethal injection in 5 years. She was the 12th woman executed nationally since 1976. Schallenberger had died by suicide in prison in 2006. Fuller remained incarcerated. The case persists in discussions of capital punishment for the questions it refuses to let rest. When two people are found responsible for the same crime, and one of them pulled the trigger and the other did not, what principle determines who receives the ultimate sentence? And if intellectual capacity is the variable in dispute, what standard of proof does justice require before deciding the question cannot be relitigated? Case 5. Clara Jane Schwartz. On December 8, 2001, a 20-year-old college student in Virginia coordinated the fatal stabbing of her own father by convincing a friend to carry out the act while she remained on campus, miles away, with a carefully established alibi. Clara Jane Schwartz was 20 years old at the time of the crime, and her father was Robert Schwartz, 57, a respected biophysicist, whose research had contributed to multiple fields of science. What gives this case its disturbing quality is that Clara did not act alone out of anger in the heat of the moment. She reportedly spent months building a narrative that made the people around her believe the act was justified, even heroic. This case illustrates something uniquely unsettling. It reveals the capacity of a person to manipulate and turn a group of ordinary young people into participants in a plan they may not have fully understood until it was already done. What really motivated Clara Schwartz to orchestrate her father's death, and how did she convince others to help her? Let's dive into what really happened. There is a particular kind of persuasion that works only on people who are already searching for a reason to believe something. It does not require force. It does not require evidence. It requires only a story told with enough conviction to a person whose own hunger for that story outpaces their ability to question it. Clara Jane Schwartz understood this in ways that a 20-year-old college student has no obvious right to understand. The question courts spent years trying to answer was whether that understanding made her a murderer. Two separate appellate courts, after reviewing the record, concluded that it did. Robert Schwartz was 57 years old and a prominent biophysicist in Loudoun County, Virginia. He had contributed to work in DNA research, biometrics, and the scientific understanding of evolutionary biology. He lived on a remote farmhouse property near Leesburg. He was the father of 3 children, including Clara, who was enrolled as a student at James Madison University in Harrisonburg at the time of his death. Their relationship, by all documented accounts, was strained. The precise nature of that strain became one of the central arguments of the trial. Clara claimed verbal and physical abuse by her father. She alleged that he had struck her and made efforts to poison her food. These allegations were transmitted not to authorities, not to school counselors, not to any institution with the capacity to investigate or intervene, but to a close group of friends deeply immersed in a fantasy role-playing game called Underworld. The game involved themes of vampires, dark magic, assassins, and occult mythology. Clara had a central presence in that world. She shaped its narratives. She was the one who decided, within the logic of the game, who was a threat and who needed to be neutralized. Prosecutors argued that the line between game and genuine intent had not been blurred accidentally. Evidence presented at trial showed that Clara had, prior to the events of December 2001, approached another individual named Patrick House and asked him to kill her father. She had researched poisons. She had discussed inheritance. When Patrick did not act, she turned to Kyle Hulbert, an 18-year-old with a documented history of mental health struggles and an obsessive identification with occult themes and bladed weapons. Hulbert understood himself to be a protector of Clara. She had given him a framework in which killing her father was not a crime, but a heroic intervention. On the evening of December 8, 2001, Hulbert, accompanied by Michael Fall and his girlfriend Catherine Inglis, drove to Robert Schwartz's farmhouse. Robert likely recognized Hulbert as one of his daughter's acquaintances and led him inside. What followed resulted in Robert's death from multiple stab wounds inflicted with a sword Hulbert had carried to the scene. The attack was severe. The body was not discovered until 2 days later, on December 10th. Clara was at James Madison University during the killing, providing herself a geographic alibi. Hulbert confessed. He stated he had been acting to protect Clara from an abusive father, precisely the narrative Clara had given him. Digital records, communications, and testimony from multiple people, including Patrick House, established that Clara had been orchestrating the effort for months. A $60 check from Clara to Hulbert, written around the time of the killing, was part of the evidence. Fall's car required a tow near the farmhouse that night, creating a record that connected the group to the scene. Clara's trial in October 2002 was the first among the co-defendants. Prosecutor Jennifer Wexton, who later served as a Virginia congresswoman and governor, presented the case as methodical orchestration. The defense argued that the directives Clara communicated had been understood by Hulbert as role-play rather than real commands, that the tragedy was the result of Hulbert's mental instability, not Clara's intent. The jury deliberated approximately 4 hours before convicting on all counts: first-degree murder, conspiracy to commit murder, and 2 counts of solicitation to commit murder. Clara was sentenced on February 10, 2003, to 48 years in prison, the jury's recommendation, which the judge imposed. She was 22 years old. Because she was not the individual who physically carried out the act, and because the aggravating factors required for capital punishment in Virginia were not met in her case, the death penalty was not sought. Hulbert received life without parole. Fall received 18 years after pleading to second-degree murder. Inglis served approximately 1 year for conspiracy. Clara's appeals, including a federal habeas petition reviewed by the Fourth Circuit Court of Appeals in 2010, were denied. She remains incarcerated at Fluvanna Correctional Center for Women, with a projected release date around November 2043. Robert Schwartz, who had spent his career contributing to scientific knowledge that outlasted him, was found alone in a farmhouse 2 days after his death. His daughter was an hour and a half away in a dormitory, with a geographic alibi and a group of friends who believed, because she had told them, that he deserved what had come to him. Case 6. Susan Cummings. On the morning of September 7, 1997, Susan Cummings shot her boyfriend 4 times with a semi-automatic pistol while he sat at her kitchen table eating breakfast. Then she waited approximately 30 minutes before calling emergency services to report it. Susan Cummings was 35 years old at the time of the shooting at her sprawling Fauquier County estate in Virginia. Her boyfriend was Roberto Villegas, 38, an Argentine professional polo player who was also her employee, entirely financially dependent on her estate. What makes this case one of the most discussed of its kind is the outcome that despite being charged with first-degree murder, Susan Cummings was convicted only of voluntary manslaughter and served approximately 51 days in jail before being released. There are cases that generate argument for decades, not because the facts are unclear, but because the outcome refuses to feel proportionate. People examine the sentence, and then re-examine the facts, and then look at the sentence again, and the gap between the two will not close. The Susan Cummings case sits in that category. But what truly happened in that kitchen on a September morning, and was justice actually served? Let's take a closer look at how it all unfolded. Susan Cummings was born in 1962 in Monaco to Samuel Cummings, a billionaire arms dealer widely considered the most significant private arms trader of the 20th century, and his wife Irma. She and her twin sister Diana grew up across Europe before the family settled in the United States. When their father died, the sisters inherited a lavish equestrian estate called Ashland Farm in Warrenton, Fauquier County, Virginia. Susan was by most accounts introverted and deeply private. She maintained an extensive collection of firearms. She was reported by those who knew her to sleep with a handgun under her mattress. The wealth she had inherited had not, by various accounts, translated into ease or openness. She met Roberto Villegas around 1995 through the polo world. Villegas was 38, an Argentine professional polo player who had emigrated to the United States in 1991. He was charismatic, athletic, and financially dependent on wealthy patrons. Susan became both his employer and his romantic partner. He managed her farm, cared for her horses, and served as the centerpiece of her Ashland Farms polo club team. She covered his expenses and accommodation. He had no regular salary, which gave her considerable leverage over his daily life. By the summer of 1997, the dynamic between them had become strained. Villegas, according to accounts from his supporters and associates, was seeking more independence. Cummings told a different story. She claimed months of escalating threats and abuse, culminating in fears for her physical safety. On the morning of September 7, 1997, Villegas arrived at Ashland Farm ahead of a scheduled polo tournament. He sat down in the kitchen of the main house to eat breakfast. Croissant particles were later found in his mouth. There was coffee nearby. Susan Cummings shot him 4 times with a Walther semi-automatic pistol. The first shot struck him in the shoulder. Subsequent shots struck his neck, severing the carotid artery, and his back. He did not rise from his chair. He died where he sat. A long-handled knife was found near his arm. Cummings sustained cuts on her arm, which he identified as wounds inflicted during an attack by Villegas immediately before the shooting. She claimed self-defense. After the shooting, investigators later estimated a period of approximately 30 minutes passed before she called 911. In that call, she stated calmly that she needed to report a shooting and that the man was dead. She said he had tried to kill her. Prosecutors raised significant concerns about the physical evidence. Villegas had been seated and eating when shot, not advancing toward Cummings with a weapon. The kitchen showed no signs of a struggle consistent with a violent confrontation, she described. Blood coagulation analysis suggested time had passed between the shooting and the call to emergency services. Investigators questioned the position of the knife, whether it had been present during the altercation or placed afterward. They also noted the nature of Cummings' cuts. The wounds were lengthwise, relatively superficial, and still bleeding freshly when officers arrived, while Villegas' blood had already begun to coagulate at the scene. The trial took place in May 1998. Cummings was charged with first-degree murder and use of a firearm. Her defense team, led by prominent attorney Blair Howard, aggressively humanized Villegas as volatile and threatening. Witnesses testified to his alleged prior violent behavior toward others. The jury ultimately rejected the murder charge and returned a verdict of voluntary manslaughter, accepting some form of provocation or imperfect self-defense. The sentence: 60 days in jail, a $2,500 fine, She served roughly 51 days before release. The public reaction was substantial. Commentators, journalists, and legal observers drew direct comparisons between her outcome and what an unrepresented or non-wealthy defendant might have received for shooting someone 4 times in a domestic setting. A civil suit filed by Villegas' son sought damages ranging from $15 to $103 million and was settled for an undisclosed amount. Books and television programs examined the case over the years that followed. Dominic Dunn covered it for Vanity Fair. It was later adapted as subject matter for multiple television investigations. Susan Cummings sold the estate, moved to another Virginia farm, and largely withdrew from public life. Roberto Villegas was 38 years old. He had built his professional identity around a sport that required proximity to extreme wealth. That proximity created the dependency that defined the last years of his life. Whether the knife near his arm was a weapon he had drawn or an object placed there after the fact is something the trial's outcome did not definitively resolve. What was resolved in the form of 60 days and a small fine remains one of the most cited examples of its kind in discussions of unequal justice in American courts. Case 7. Elizabeth Haysom. Around March 30, 1985, a University of Virginia student helped plan and arrange the brutal stabbing of both her parents at their Bedford County home, then spent years at the center of one of the most debated criminal cases in Virginia history. Elizabeth Haysom was 21 years old at the time of the crime. Her parents were Derek Haysom, 72, a steel executive, and Nancy Haysom, 53, an artist. What makes this case persistently controversial is that the man convicted as the principal perpetrator, her boyfriend, Jens Soring, has maintained his innocence for nearly 4 decades, claiming his confessions were false. New forensic evidence has since reignited the debate, and legal proceedings continued as recently as 2026. The questions everyone is asking about this case are, what role did Elizabeth Haysom truly play in the deaths of her own parents? And how did a university romance become something this devastating? Let's piece together the events of this case. Young love is one of the most disorienting forces in human experience. It reorganizes priorities. It collapses perspective. It persuades people, especially young people still forming the architecture of their own judgment, that the relationship they are inside is more real, more significant, and more entitled to survival than almost anything outside it. What Elizabeth Haysom and Jens Soring had in 1984 and early 1985 was, by multiple accounts, exactly this kind of intensity. The problem is what that intensity became. And the larger problem is that 40 years later, not everyone agrees on what it became or who should bear the greater weight of it. Elizabeth Haysom was born in 1964 in what was then Southern Rhodesia, now Zimbabwe, to a South African father named Derek, a steel executive, and an American mother named Nancy, an artist. The family had a complicated structure. Half-siblings from prior marriages, a history of movement across continents, and a lifestyle that was financially privileged, but emotionally turbulent by various accounts. Elizabeth attended elite boarding schools in Switzerland and England before enrolling at the University of Virginia as an Eccles Scholar, the designation given to particularly high-achieving students. She was intellectually capable, complicated, and, as her own letters would later reveal, harboring a deep and long-standing resentment toward her parents. In 1984, she met Jens Soring, a 19-year-old German student and Jefferson scholar whose father was a diplomat. They formed an attachment quickly. By winter break of 1984 to 1985, Elizabeth was writing Soring letters from her parents' home that described her feelings toward her mother and father in terms that ranged from bitterness to frank expressions of violence. She wrote of wishing them dead. She wrote of imaginary accidents. She described her father as controlling and her mother as a heavy drinker. A complicated allegation of childhood abuse by her mother, including claims of inappropriate photographs, emerged in later testimony and has remained disputed across the decades. On or around March 30th, 1985, Derek Haysom, 72, and Nancy Haysom, 53, were found stabbed to death in their Bedford County home, a property called Loose Chippings. The crime scene was extreme in its violence. Derek had sustained 36 stab wounds and injuries to his throat consistent with near decapitation. Nancy had also suffered multiple stab wounds and similar throat injuries. There was no forced entry. High blood alcohol levels were found in both victims, consistent with a shared meal that had preceded the attack. The violence of the wounds reflected, in the language investigators used at the time, something more consistent with personal animosity than robbery or random crime. Elizabeth and Soring had rented a car that weekend. They told investigators they had taken a trip to Washington, D.C., seeing a film and staying at a hotel. The rental car's mileage told a different story, approximately 400 extra miles, consistent with a round trip to the Bedford County property. Both initially presented as cooperative. Elizabeth helped organize her parents' funerals. Investigators identified the mileage discrepancy. The couple eventually fled to Europe. They were arrested in England in 1986 on check fraud charges. Both made confessions. Soring confessed multiple times, attributing the killings to himself. Elizabeth pleaded guilty in 1987 to 2 counts of accessory before the fact to first-degree murder, receiving 2 consecutive 45-year sentences. She also testified against Soring. He was tried separately in 1990, convicted of both murders, and sentenced to life in prison. The controversy that has attended this case for nearly 4 decades centers on Soring. He has maintained, since the late 1980s, that his confessions were false, offered under the belief that he, as the son of a German diplomat, would be transferred to Germany and face a more lenient juvenile sentence there. His defense has been supported by documentary evidence, including a 2015 film, Killing for Love, and subsequent Netflix programming. DNA evidence developed in more recent years has identified material from an unidentified male at the scene that does not match Soring, fueling renewed advocacy. In 2026, filings continued seeking review of the forensic record. Critics of his innocence claim point to the number of times he confessed, the detail contained in those confessions, and the fact that his convictions survived multiple rounds of appeal. Elizabeth Haysom served approximately 32 years at Fluvanna Correctional Center for Women. She and Soring were both paroled on November 25, 2019. Haysom was deported to Canada in early 2020. She has maintained a low public profile since. Soring was deported to Germany. He has continued pursuing exoneration through the courts. Derek and Nancy Haysom were killed in their own home after what appears to have been a shared meal. They were in the last years of lives that had spanned continents and professions and family configurations of real complexity. Whatever they may have done or failed to do as parents, and Elizabeth's allegations regarding her mother remain disputed by family members, they were not given an opportunity to respond, to change, to defend themselves, or to say goodbye. Case 8. Jacqueline Bledsoe. On the night of June 4, 2022, 56-year-old Jacqueline Bledsoe shot and killed her partner in a barn on her property. Then, instead of calling for help right away, she moved his body so it would not disturb her show dogs. She then left the county late at night and waited nearly 3 hours before calmly making a non-emergency call to local dispatch to report what happened. Jacqueline Bledsoe carried out this act in Bumpass, Virginia. Her victim was Melvin Hansen, 59, a tenant on her property and her on and off partner, described by his family and multiple witnesses as affectionate, nonviolent, and deeply devoted to her. What added a technical dimension to this case was the use of vehicle forensic data, tracking the movements of her car on the night in question, which prosecutors described as a novel tool in that jurisdiction at the time of the trial. What truly motivated Jacqueline Bledsoe on the night of June 4, 2022? Let's walk through the timeline step by step. Jacqueline Bledsoe, 56 years old, lived in Bumpass, Virginia, on a property on Belmead Road, where she also raised show dogs, primarily beagles. Melvin Hansen, 59, was both her on and off romantic partner and her tenant. He lived in a trailer on her property and performed work, including tree services. By accounts from multiple witnesses, including Bledsoe's own mother, the relationship dynamic was one in which Hansen was demonstrably affectionate toward Bledsoe. Her mother described him as following Bledsoe closely, attentive and devoted. There was no violent history attributed to him. His family, children, grandchildren, and great-grandchildren described him consistently as gentle and non-confrontational. On the evening of June 4, 2022, at approximately 9 in the evening, Hansen sent Bledsoe a text message ending the romantic aspect of their relationship. Whatever had been building between them in the weeks or months before that text, it arrived that night as a final statement. Bledsoe's response to it, prosecutors argued, was neither acceptance nor grief. It was a decision. Her account of what followed was detailed. Hansen had allegedly become angry upon her response to the text, accused her of involvement with another man, chased her up the driveway, pushed her to the ground, and choked her multiple times. She said she had retrieved a 20-gauge shotgun from the barn in fear for her life, warned him to stop approaching, and fired when he did not comply. The shooting, in her telling, was the terrified response of a woman convinced she was about to be seriously harmed. Investigators found no injuries on Bledsoe consistent with the sustained assault she described when she was examined after her arrest. Hansen had no documented history of violence. What investigators did find, as they reconstructed the evening, was a pattern of post-shooting behavior that was not consistent with the spontaneous panic of a genuine self-defense situation. After the shooting, Bledsoe moved Hansen's body out of the barn. She explained this in a non-emergency call to law enforcement, made approximately 3 hours after the breakup text, not immediately after the shooting, by saying she had not wanted her dogs upset by having the body present where they were kenneled. She then left her property. Vehicle forensic data placed her car traveling to a rural area of Hanover County in the late evening hours, suggesting a possible effort to identify a location for body disposal. She then drove to a neighbor's home 3 doors away. That neighbor declined to help move the body. She also contacted another neighbor and asked that person to enter Hansen's trailer, retrieve his phone, and delete messages and emails from it. When Bledsoe took the stand at trial, she testified for over 4 hours. She maintained her account of fear and physical assault. She referenced bruising on her elbow as evidence of the attack. Prosecutors noted that this bruising had not been mentioned or observed during earlier interviews and had appeared after a break in the police questioning process. The jury deliberated briefly, what the Commonwealth's attorney described as one of the fastest verdicts in his murder trial experience, and returned guilty verdicts on both second-degree murder and use of a firearm in the commission of a felony. The case reached the Virginia Court of Appeals, where Bledsoe challenged the sufficiency of the evidence supporting her conviction. The court, in a ruling issued in October 2025, affirmed the lower court's judgment. She remains incarcerated. The sentencing, which followed a January 24, 2024 hearing, imposed penalties appropriate to the charges. Virginia's abolition of the death penalty in 2021 meant capital punishment was not a factor in the proceedings. Melvin Hansen's family offered victim impact statements, describing a man who was central to multiple generations of a family. He was a father and a grandfather and a great-grandfather. His children expressed gratitude for the conviction. They also expressed the particular grief that comes from losing someone to an act of violence that a text message had precipitated. The knowledge that a brief, direct communication about the end of a romantic relationship had been met not with acknowledgement, but with a loaded shotgun. The vehicle forensic evidence introduced in this case drew some commentary from legal observers because of its novelty in that jurisdiction. Data from Bledsoe's car told a story her words had not. The late-night drive to Hanover County existed in the record independently of whether she chose to explain it. That kind of evidence, drawn from the machine rather than the memory, does not accommodate the adjustments that human testimony can make under pressure. Case 9. Jennifer Mulligan. On the morning of May 7, 2025, 43-year-old Jennifer Mulligan walked into her 90-year-old father's bedroom while he lay in his bed, raised a handgun, fired a single shot, then stepped outside and called 911 to report exactly what she had just done and why. Jennifer Mulligan's father was Woodard McClure, a man who, according to Jennifer and multiple siblings who spoke to investigators, had subjected his children to years of severe abuse. What gives this case its particular complexity is that Jennifer never denied what she did. She confessed immediately, cooperated fully, and the abuse history she described was corroborated by family members from the very start of the investigation. What does it mean when the law and the human story behind a crime point in completely different directions? Let's uncover the truth behind her actions. There are cases where the legal framework and the human reality sit in uncomfortable proximity to each other, where the facts are not in dispute and the law is being followed, and still something about the full picture refuses to resolve neatly. Jennifer Mulligan's case is one of them. Jennifer Mulligan was 43 years old at the time of the shooting. She had been serving as her father's primary caretaker for approximately 2 years, since the closure of the nursing home where he had previously resided, around 2023. Woodard McClure was 90 years old and had dementia. He required constant care. He was entirely dependent on whoever was in the house with him. The person in the house with him was a woman who, according to her own account and the accounts of her siblings, had spent decades managing the weight of what he had done to them as children. Multiple siblings told investigators that Woodard McClure had subjected them to sexual abuse over many years during their childhood. Court records and supporting statements indicated that Mulligan had directly confronted her father about the abuse at some point, and that he had admitted to it. The nature and duration of the abuse, as described across multiple accounts, had left lasting effects on the siblings individually. Mulligan's attorney, Roger Whitus, described a pattern that included trauma from both her father and a former husband, with cycles of harm extending across decades of her life. On the morning of May 7, 2025, Mulligan had consumed 3 beers. She retrieved a .380 caliber pistol from a closed box in the garage. She went to her father's bedroom. He was lying in his bed. She fired a single shot to his forehead. Autopsy results confirmed death by homicide from a single gunshot wound. She then walked outside and called 911. The call was direct and unambiguous. She identified herself as having shot her father. When the dispatcher asked if it was intentional, she confirmed it was. She told the dispatcher that he was a rapist and a child predator. She told them he was not a good person. She waited calmly outside the residence for officers to arrive and was taken into custody without resistance. In a subsequent interview with a detective, she said she had done what she felt she had to do to address the suffering, that she had held herself together for years, particularly for the sake of her own children, and that on that morning she had simply broken. No evidence of dispute or struggle was documented. The scene was consistent with a deliberate act carried out swiftly and without complication. Police recovered the handgun and a spent casing. Mulligan consented to searches of her phone and other property. She provided consistent statements throughout. A preliminary hearing in September 2025 included the playing of the 911 recording, which detailed the abuse allegations and her stated reasoning. Mulligan was originally charged with first-degree murder. On April 14, 2026, she entered a guilty plea to second-degree murder and use of a firearm in the commission of a felony. The first-degree charge was reduced as part of a plea agreement, with the mitigating factors of documented trauma and decades of abuse cited as central to the negotiation. The plea agreement called for 40 years on the murder count and 3 years on the firearm charge, with active time capped near the sentencing guidelines midpoint, meaning approximately 17 years was the expected active sentence. Sentencing was scheduled for August 4, 2026. Virginia's abolition of the death penalty made capital punishment inapplicable. She remained in jail pending the sentencing date. Defense attorney Whitus, in public statements following the plea, described the case as profoundly difficult and noted Mulligan's courage in surviving what she had survived. Family members and friends attended her hearings and offered support. The siblings whose accounts corroborated the abuse history were present in the proceedings. Their presence and the consistency of their statements shaped both the public understanding of the case and the outcome of the plea negotiation. What makes Jennifer Mulligan's case resistant to easy categorization is not what she did. She has admitted to it completely and openly, but what preceded it by decades. She was a woman who had spent her adult life managing a wound that most people never have to carry. She became the caretaker of the person who had caused that wound when no other arrangement was available. She did so for 2 years, with dementia complicating the daily reality, before something broke. Woodard McClure was 90 years old. He died in his bed from a single shot fired by the daughter he had once had every obligation to protect. The act cannot be separated from what preceded it, and the legal system, through the plea agreement, through the reduction from first degree to second degree, has acknowledged as much. What comes next on August 4, 2026, will add a sentencing figure to a case that has been unusually transparent, unusually cooperative, and unusually burdened with history from its very first moment. Thank you for watching.